and the participant of this very conference. Please, my name is Amin Garba. I'm the Director of ICT Nigerian Police Academy, Wudil, Kano, and Coordinator Cyber Forensic of the Academy. I'm here to present a paper title or topic, Assessing a Homicide Victim Smartphone to Help Resolve the Crime. We are focusing on the admissible evidence, entirely digital evidence, but mobile phone forensic in focus. Here along with me, there is Barrister Shehu Meiyaki, who is to tackle the legal aspect of the presentation. And I am to discuss about the technical aspect of the digital forensics with emphasis on mobile forensic on homicide cases. I am to be supported by Abulfathi, Ibrahim, Saleh, Al-Hussaini, the PhD, fellow, Forensic Investigator Society of Nigeria, who I am to announce his absence due to some activities that he was taken off with. In that course, let us start with a word digital forensic and its branches. The technical aspect of an investigation entirely and specifically in digital forensic is divided into many sub-branches. Depends on the type of device that you are going to examine. In that course, the following areas in digital forensic has to be considered while you are talking generally about digital forensic. We have computer forensics, database forensic, network forensics, firewall forensic, and mobile forensic. If we could remember from the beginning of my presentation, we are to focus on the mobile forensic because we are to assess the victims of homicide phone to extract a kind of admissible evidence that will be used to present in the court for a viable conviction. So here now, we are talking about the history of cell phone forensic, which originated in Europe and focused on GSM, SIM card roaming of devices from network and spectrum required ID and info and on SIM and the information that we can get on a SIM. Due to that, mobile forensic has become a kind of point of discussion because now majority of this insurgency and terrorism are used by those terrorists and insurgents to increase the demand of mobile forensic. So due to the rapid acceptability of mobile phone, the adoption has moved quickly from federal to local level and to enterprise level, meaning there are some private investigators who are involved in digital forensic investigation and mobile forensic investigation. In a nutshell, mobile forensic investigation is now the key factor of committing either cybercrime or cyber terrorism. The basic forensic process the basic mobile forensic process is that a typical digital forensic process involves the following stages. We have phone seizure, meaning how could the phone be acquired by a law enforcement or a private investigator so that he may get access to it for a kind of data extraction. Then we have a forensic imaging. After the phone has been seized or the phone is in custody, a mobile forensic expert will extract the data through a process called imaging. Then the second stage is analysis of the image data. The data that was extracted has to be analyzed, after which it will be presented as an evidence in the court of law. So if we can look at this slide, we can see that there are some examples of digital forensic devices. We have this, we have phone, we have these computers, we have tabs, we have iPad, we have iPhones. All these form of digital devices are those that a digital evidence can be extracted. But if we could remember now, before going directly to an issue of mobile forensics, we may need to know or to define the word evidence, which can now be defined as a piece of information that supports a conclusion. And the digital device is any data that is recorded or preserved on any medium by a computer system or other similar devices that can be read or understand by a person or a computer system or other similar devices. If you can look at this slide, we can also look at the characteristics of digital evidence. A digital evidence can be admissible, meaning conformity with the common law and legislative rules. An evidence can be admissible if there is any rule that governs it to be inadmissible. Secondly, we have an authentic. An evidence can be an authentic, meaning in linking data to a specific individual and the event, meaning the connectivity between the data that is extracted as an evidence and the crime scene, the victim, and the accused. The evidence has to have that connectivity. If the evidence doesn't have that connectivity, it is not authentic and it cannot be admissible in that cause or in a particular case. Majority of our evidences that are presented in the court lacks connectivity, lack this authenticity. It means that is merely the connectivity is missing. An evidence in crime scene A, which is entirely doesn't have any connection with crime scene B, cannot be used as an evidence in crime scene B. Then we have another characteristic, which is the fragile. The fragile nature of digital evidence means it can easily be altered, damaged, or destroyed. But in a nutshell, digital evidence, even if it is being deleted, damaged, or destroyed, it can be recovered using a special tools in that cause. Another characteristic is the accuracy. The accuracy of an evidence means believed and is consistent, meaning linking with a particular crime and the chain of custody that led to that accusation of that evidence. We have another characteristic which is complete, which refers as the evidence with a full story of a particular circumstances. The same meaning of connectivity. If an evidence doesn't carry any element of connectivity between among these 5 elements of or 5 ingredients of conviction, that evidence is not complete. The evidence has to have connection with the crime, that the evidence that the crime scene, that the crime was committed, the victim, the accused, and the suspect. So in that case, it has to be complete. The last characteristic is convincing to judge or jury. Without a practicing judge system, or the judge as just to decide the judgment, the evidence, the judge has to be convinced on the evidence that is standard that he's using for a particular conviction, meaning to have a probative value, subjective, and the practical test of presentation. To prove it, to convince a judge beyond reasonable doubt. These are the characteristics, are the general characteristics of digital evidence, and it can be applied. Some of these characteristics can be applied to a physical evidence as well. You see, source of digital evidence based on their location. Many courts allow the use of email, digital photograph, ATM transaction logs for a bank fraud, word processing document, instant messaging history, file saved, and so on. The content of a computer, memory, and so on. The type of digital evidence. You see, the type of evidence here, we have a persistent data. This is a data that remains intact and accessible when the device is turned off. Example, has a hard disk of all kinds of removable digital storage devices. This type of persistent data, it remains intact. Even if the computer is or the device is off, we can remove the hard disk and extract the content of the evidence because it is intact and it is never be deleted. It is permanently stored in the hard disk of the digital device. Example, ROM. Volatile data. This type of data is a data that should be lost when the digital device is turned off. Example, web browsing history, temporary file, cookies, etc. But with the advance of the advanced tools, there are some tools that can, there are some tools that can be used to extract some of the issues. There are some tools that can be used to extract some of the evidence on real-time activities. We have metadata. I mentioned metadata because I'm interested in metadata in that particular presentation, because majority of our investigators and law enforcement agents do not understand or are not in awareness of the types of these two data, if it is regarding the issue of CDR or this tracking of mobile phones. A metadata is structural information that describe, explain, locates, or otherwise make it easier to retrieve, use, or damage an information resource. A metadata it means an information about an information. So I'm going to talk much on this metadata later. So the types of digital evidence, as I mentioned earlier, based on location, this is the type of digital evidence as well. Internet history files, temporary internet files, and so on. The mobile forensic. The scientific extraction, examination, analysis, and presentation of digital evidence from mobile phones domain, such as SIM, embedded phone memory, phone SD card, meaning external card that is inside in a phone, and other information from service provider, meaning mobile communications, in such a way that the information can be used as an evidence in the court, is called a mobile forensic process. Now, a mobile forensic continuation. Mobile forensic, as we are dealing with mobile phones, there are some technologies that came on with the mobile phones. We have CDMA, we have TDMA, we have GSM, we have FDMA. The CDMA stands for code division multiple access and time division multiple access. GSM, we have LTE after this. An investigator have to understand that there are certain phones that are seamless. The CDMA, TDMA, and some of these are seamless. It doesn't contain SIM. So on the course of extraction, you have to know that which location are you going there to extract the relevant evidence. And if you are using GSM have a SIM. LTE have a SIM. So your scope of investigation has to increase. In that course, the general location, the general ethics based on the location of an evidence to be found in a mobile forensic, we have about 4 locations where a data can be extracted using a mobile forensic process. Now we have a SIM which is subscriber identity module. It contains some data that are relevant for a law enforcement agent to prosecute an accused based on it. We can also extract an evidence or data from a mobile phone in a location called embedded phone memory. Majority of our phones depends on their manufacturing structure or architecture. We have a phone that's tagged as GSM and LTE that has these 4 possible locations where a data can be extracted: SIM, embedded phone, memory, SD card, and service provider. The other phone doesn't have that. A phone that doesn't have SIM, you cannot locate where this information is. You have to go to that, either this the SD card or directly to the service provider, because majority of some of the evidence are especially content data, especially content info data are residing on the service provider's wing. So now we will be interested to ask on the operating system on a mobile phone after knowing the architecture, the technology and architecture. Now the mobile phone has their own operating system, not like PC. We have Symbian, which is a mobile phone operating system. We have Research in Motion, which is an operating system that is used on a BlackBerry phones. We have Farm OS, which are used on farm-related phones. I have not listed iOS here, which is used for an Android phone. We have Linux that is used for a Linux phones, and so on. We have to also have an interest to know the physical architecture of a mobile phone. The typical hardware component of a mobile phone categorized into 3 possible architectures. We have high-end, which is normally 16-bit color display, super storage, and processing, memory, input and output card slots. We have infrared, Wi-Fi, Bluetooth, video, and still camera. This is an example. This type of phone, the architecture is called high-end because they have the full option facilities. So an investigator that will investigate this kind of phone has to have an extra knowledge in order to understand how could he arrive at a particular evidence of interest. We then have an advance, which is an architecture that is not up to that high end. If you see, it has 12-bit color display, additional storage also, memory card slots, infrared, and so on. Let me talk something very important. Maybe majority of people that are using phone, maybe they have not looked at that angle. Infrared is something very good to be used on a phone. And now some technologies overtook it. But it's very good. You can use infrared to make your phone to be a kind of remote control. A phone that doesn't have that, it will not be used as a remote control. This issue is that I'm interested in that issue because terrorists are using phones that have infrared to remotely ignite a kind of mission on other device remotely. So if this issue happens, or you are an expert who witnessed in that cause, the phone that was seized from the suspect, if it doesn't have that infrared and any facility that can act to remotely have an access to another device, it will give you a clue on maybe he doesn't use that, or he's not the one that triggered that particular mission. We don't have a basic, which is an ordinary phone, which we call in Hausa Lado Lado. Lado Lado means it is just an ordinary phone that doesn't have all these qualities that I mentioned above. This is the typical hardware component of a mobile phone. This is continuation on it. Then we have, now, after we know all this, we know how mobile phones architectures are, how their operating system are. We may need to know what can be pulled from the device based on case scenario from the logical tools. We can extract many of the evidence, as I mentioned earlier, from the phone book, call history, and detail to, or from, meaning he who called, callee and caller, the duration of call, text message with identifiers, sent to, and originating, meaning the one that sent text and the one that received that text. Received deleted messages can also be extracted either from the end of service provider or from the SIM if the message was saved on the SIM. Multimedia text message with identifiers, photos, and so on due to time. Accusations slash data capture option. This is very important for an investigator to be aware of, because in an investigating phone, you have to clearly state that which data capture option do you use in the case of expert witness in the court. If you are not lucky, you met an expert who read vastly, and you went there and conduct your extraction, presentation, analysis, documentation. You are there to present, and you met an expert that knew what he's doing, I think he can drag you down by saying that, can you tell me the data caption option you use in extracting those evidences? You have to specify. That is the result that can be made by through screen capture, logical analysis, physical analysis, analysis, and so on. So in that aspect, this time we can go ahead and go to what are mobile forensic tools. While a lot of forensic tools are used to gather lost data from laptops, since billions of people use their phones daily, there is a tons of data that can be gathered from mobile phones for forensic analysis. The complexity of mobile device and their operating system is continuously rising. When criminals use smartphones, law enforcement agencies, investigators, and attorneys require robust tools to perform evidence extractions. This means that now there are certain phones that if you don't have an up-to-date tools, you cannot extract what you need to extract from that tools. That is why in the report, as an expert witness, you have to state the tools that you use in extracting those evidences. Even though some are extracting an evidence from the back door, but I don't think that the visibility will be okay to extract a kind of evidence illegal. But this, I don't know, maybe Barrister Shehu will shed more light on that later. But now we have the best mobile forensic tools for iPhone and Android, 2022 review. Before, we are using a lot of mobile phones forensic tools like mobile edit, X-ray, oxygen, blah, 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 and so on. Now there are some robust mobile forensic tools that are used, which are so much consistent and are reliable. Now we have E3DS software, at times called Paraben E3DS. It's an advanced forensic mobile solution for data extraction and forensic analysis. This type of software is very powerful and can do a lot to extract large variety of data types. We have Passwire. Passwire provides an all-in-one solution for password and data recovery, and so on. We have Beckersoft. Beckersoft offers a versatile forensic software to acquire all sorts of data from different devices that run on popular operating systems like iOS and Android, meaning iOS means an OS for iPhones. With Beckersoft, you can gather data through different methodologies, including agent-based accusation and check KM8. You can gather crucial knowledge from some of the most popular apps, including Instagram, WhatsApp, and a lot more. They also facilitate cloud forensic investigation, which can be an excellent addition to your existing case. There are issues where a lot of people are saying WhatsApp is secured. You can secure your calls, your conversation, your chats on WhatsApp. So I think the participant will go and read more on that Becker soft to find out whether if you are talking to a person of confidentiality caliber, you may miss something or you may be scared. We have UFED Ultimate and ECOMOS IOS Forensic. Now, after we now talk about a mobile phone forensic, the key factor that we need to lie our eyes, ears, hands on is if now as victim of homicide has a phone that was found on the crime scene, what do we need from that phone? What type of data we need from that phone as an evidence, and how? After checking his phone, we have to check the phone. After checking it, we have to find out where are the traces based on the call, based on the chat, and so on. If we find out a traces, meaning a phone that he receives, what can we do with the phone, with the number that the person of victim of homicide receives? I think we have to look at the phone series of call history that he receives and run a kind of CDR. The CDR I mean is not the one that I normally see. What I'm trying to unveil here is the CDR that is usually used to be presented in the court. It missed some portion, integral portion, a weighty portion, which carries a lot of weight in prosecuting that very suspect or accused. Now, if you run a CDR, what do we expect to have from CDR? You see, there are a lot of information that we found in CDR, but what we need is the content data, not content information. The content information is the metadata, is the information about the information. If I call a person, someone called him, another person called him, and that person was found dead. So I will not be exonerated whether I'm the one who called him, who sent a threat message or threat conversation to him. Amongst we that calls him, we cannot know exactly who is the actual perpetrator of his murder till we have that content data, which will reveal the actual conversation if there is not a threat test. A threat test is clear. We have a text, someone texts him, we find a text from his phone that we are coming to kill you or so time, or any other threat statement. That is obvious. But we have to have the real conversation, which is content data from the service provider. I think Barrister Shehu Meiyaki will shed more light on whether the service providers are carrying their own duty based on the Cybercrime Act. So another slide here. It is a typical architecture of how call detail is being recorded and reside at the mobile and service mobile phone service providers end. You see, look at this. If you see, look at the call detail record. Majority of service providers that fail to offer the, what can I say, the real call conversation. Maybe, I don't know what they based on, or the people who requested that information, they are not aware of their rights on having that record, or the service providers deny them intentionally. But the Shehu Meiyaki will unveil that issue. All we have to know is that service provider recite both content and non-content data, which means the real conversation and the information about the conversation. So the call detailed record technical attributes. Due to time, I will now hand it over everything to Barrister Shehu Meiyaki so that he may discuss the legal perspective of this presentation. Okay.
Hello, good morning. Hello, good morning, gentlemen. Am I audible?
Good morning.
Yes.
Yes, you are. Go ahead, sir.
Thank you very much. The president of the Forensic Society Investigators Nigeria, the registrar, the presenter, the speakers who have spoken yesterday and today, the participant, my co-participants, and other persons listening, I say a very good morning to everybody. Yes, morning, I'm sure from the presentation made by my Oga Amin Muhammad Garba, who has actually injected me with the spirit of going into this area of forensic science. I have learned a lot from him. Now, like he rightly pointed out, we are going to look at, or rather, I'm going to, part of the paper presentation, even though in a very summary form, is to identify, consider, and look at the legal implications or the legal position concerning this issue of what you call the smartphone of a victim. Now, as we are aware, because my own presentation, with all respect, is going to be the practical application of the law in relation to the investigation of the victim's smartphone. And we know technology in this our 21st century has changed drastically the way of living, the way we think, the way we conduct our businesses, the way, and maybe the way we sleep. Well, one of the areas affected by these changes in what you call the ICT, information technology, has to do with the crime, investigation of crimes generally, and in particular homicide cases. Now, in investigating homicide cases, as per the topic here, the title of our paper, our focus is on the victim's smartphone. Now, if an investigator or a law enforcement agency is investigating a particular case of homicide, now he may have or he may come across the victim's smartphone. That victim's smartphone may help him at times to find out information, to find out details, to find out maybe suspected persons that may be connected with the crime. So that is why it is important at this point to look at the position of the mobile phone, and then what is the position of the law concerning having that access. Now, I said in this regard, the questions, some basic questions has to be taken into consideration. The legal basis for the use of digital evidence that is on the smartphone of the victim. Secondly, we have to look at whether the law enforcement agency who came across the victim's smartphone require consent or permission to access the said phone. And thirdly, considering the nature of the data to be extracted, how and where could the content and the non-content aspect of the data in the smartphone be reliably found and or obtained for use by investigators. Because like I've said earlier on, the purpose, because the starting point of investigating any crime, particularly in murder cases, lies predominantly in the investigative aspect. If the investigation is perfectly done, is reliably done, is smartly done, is professionally, forensically done, then that will help in order to have a very presentable evidence to be relied upon and to be used that will connect. I'm sure my learned friend, sorry, my friend Mala Aminu has spoken extensively on the technical aspect of the presentation. So like I was saying, these three questions are key. They are very crucial, they are fundamental in doing, or rather in assessing the smartphone of the victim in order to extract information that is relevant. Now, from the presentation made by Mala Aminu, two issues, I think two critical things has to be understood or re-emphasized at this point. Now, if the investigator, or rather the law enforcement agency, handled or came across the smartphone, and the question is that, can he assess, is he entitled by law to directly go ahead and open it and see whether he can get any relevant information? So that question is a very fundamental question that we have to look at. Now, taking into consideration of the privacy, the right to privacy that is enshrined in the Constitution and other provisions of the law. So So I was saying that now we discussed the issue of what you call the Evidence Acts, what gave the room for admissibility of the evidence extracted or that may be extracted from the smartphone of a victim. Now, reference has been made here to the provision of Section 68 of the Evidence Act. Now, Section 68 of the Evidence Act is very apt. It has to do with the issue of what you place, which is to be presented before a court of law. Now, when it reads as follows: when the court has to form an opinion upon a point of foreign law, customary law, of custom, or of science or art, or as to the identity of handwriting, that one has been is not directly an issue, has been tackled by the previous presenter, or fingerprint impression, the opinions upon which the point of person specially skilled in such foreign law, customary law, or custom, or science, which is with emphasis now underlined, or art, or in question as to identity of handwriting or fingerprint impression are admissible. Now, the bottom line or the underlying factor is that this particular section has given room for what? For the admissibility of evidence of experts. Now, when, for example, in the course of the investigation, now the handset or the smartphone of the victim is found and information extracted, there are certain aspects of the information that has to be analyzed, interpreted by an expert. And in this case, a forensic science, an expert in that area would be called upon to examine, to analyze some aspect of the content of that smartphone, depending. Now, the next aspect which we have, which I have taken into consideration is the computer-generated evidence. Now, we all know that computer evidence is digital evidence. It's an evidence which is extracted, as can be defined here. It is evidence specifically refers to the evidence which is available in digital form or binary form. consisting of numbers and 0-1. It originates from multitude of sources, including seized computer hard drive, and backup media, real-time e-messages, chat room log, internet service providers, ISPs records, web pages, and digital network traffic. It includes local and virtual database, digital directories, wireless devices, memory card, and digital camera. So specifically, we look at if we look at that provision of Section 84 of the Evidence Act, the provision actually gave room for the admissibility of the computer-generated or digital evidence, including the content and the information or data found on a victim, on the victim's smartphone. Now, what is more important to consider at this point is the provision of the Cybercrime Act 2015, especially that dealing with the duties of service providers. Now, Mr. Aminu has already put a rider to that effect. He specifically mentioned that, you see, by the time you assess the victim's smartphone, the data, the information, depending on whatever you are looking for, may be resident in two different. Some may be resident within the phone itself, on the phone, which can be assessed, analyzed by an expert. There are certain classes of information that you have to now liaise, or you have to go to where? To the internet service providers or the intermediaries in order to get them. And these are the crucial or vital part of the document that could be or can be presented before a court of law, which has to be done in the course of the investigation and to be presented before a court of law. Now, what are the duties of service providers in that respect? Hello? 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 Are you with me?
Hello, sir. We can hear you.
Sorry, because it's like there was an interruption of talking somewhere. Sorry. Now, Section 38 of the Cybercrime Act 2015 has actually placed some duties or obligations on the internet service providers in relation to data or information that are contained, because they are the intermediaries through which platform of communication are being provided. Now, their Section 38 of 1 says a service provider shall keep all traffic data and subscriber information as may be provided by the relevant authority for the time being, responsible for the regulation of communication services in Nigeria for a period of 2 years. Now, practically, we used to experience a lot of difficulties. There are occasions in the course of investigation, now smartphone of the victim was assessed and the information, the content data information and the non-content data, the non-content data found. Now, how do we now locate? How do we get them through the service providers? You now approach them, and at times, with all respect, they will tell you that once the information has passed a period of 3 months, they cannot avail to the investigator. But you see, I think that is actually a denigration of their responsibilities as contained in the Cybercrime Act 2015. Because Section 38 says that they shall, it's not actually a matter of, an issue of option, it's an obligation. And the period is that they must. So what we are saying now in essence is that perhaps they're either not complying with the provisions of the act, either deliberately or ignorantly. But then this is actually the position of the law, and they are responsible, they are under obligation once the data required by the law enforcement agency or the investigator in a murder cases or homicide cases, as the case may be, they are entitled to update, to give provided it is relevant. 2 years is the minimum, and that is should be taken into account. And now another issue which is very crucial and sensitive, my Ogamala Aminu has mentioned, is the issue of the non-content information and content data, which is provided in section 82 sub 2A of the same Cybercrime Act. That aspect is also very important. You see, practically what is obtainable, especially in respect of what we call the call conversations between probably a suspect who has spoken or communicated with the victim. Now, we discover that if you approach the ISPs, internet service providers, mostly what they provide is the non-content, which is called the metadata. The metadata is an information about information. It only carries some aspect of the information regarding either the communication, the conversation, or whatever that took place through the medium of the smartphone or the what you call the handset or smartphone or the phone or the victim. But then what actually transpired? In most cases, these are not provided by the internet service providers or the intermediaries. And I think that is also a refusal to, rather, they are not complying in a nutshell with the strict wordings and provisions of the Cybercrime Act 2015, because it mentions specifically the non-content and information and the content data. And in most cases, improving what really transpired, what happened between the victim and maybe the defendant or the suspect, as the case may be. By the time you present that to court, the investigator, or rather the law enforcement agency, wherever he came from, may have a difficulty, especially when he's able to have or to come across in the course of cross-examination by an expert, specially skilled and who has knowledge of this issue of content and non-content data information. So I think in the final note, I would say that the provision of the Cybercrime Act is very apt. It has tackled the issue of the content and non-content information, which are very crucial, which will assist the law enforcement agencies in the discharge of their responsibility, especially the investigation. Like I said, the ball game of criminal prosecution lies, the bottom line lies on the investigative aspect. Once the investigation is not sound, once the investigation is not clear, whatever you are going to produce before a court of law certainly may not stand. And the end result is that the accused person may be discharged, not because there is no evidence, not because there is no information, fact, data to prove, but because of predicaments that has been encountered in the course of the investigation. So thank you very much. This is the little I can share with you this morning. And I'm sure there are some other participants who are lawyers and even who have privilege to have read some information better. And I believe they will also make their own contribution in this regard, particularly on the legal perspective, on the legal aspect of the digital evidence relating to the smartphone of the victim. Thank you very much for listening.